Hi everyone, I'm Adriana Giometti, Chief Marketing and Client Relations Officer at Holman Webb. With COVID-19, we're all experiencing some intensely challenging times. To help you navigate this, we've developed the Legal Lockdown series, where I'll be speaking to lawyers across the firm and other experts whilst in lockdown about issues, opportunities and reforms that are significantly affecting the way we do business across the country. Tal Williams joins me today. He's a partner in the corporate and commercial team at Holman Webb. Hi Tal, how are you?
Morning, Adriana. Very well, thank you.
Good. Look, I wanted to discuss residential and commercial tenancies with you today. There seems to be a lot of confusion around this topic. Could you tell us where the government's standing at the moment and if there's been any regulations that have been released that can shed some light?
Yeah, certainly, Adriana. And you're right, there has been a lot of confusion about what's actually occurred. And we've got to separate them into three areas. There's residential leases, which are dealt with in one set of legislation. There's retail leases, which is dealt with in another set of legislation. And there's more general commercial leases that are in some regards unregulated, but the Conveyancing Act does have some requirements in relation to those commercial leases. Now, back on the 30th of March, a Act was passed by the New South Wales government, and I'm just using New South Wales as an example, other states have done similar things, whereby it indicated that they were going to bring in regulations that were going to assist landlords and tenants in dealing with this COVID situation. Now, in only one of those three areas have the regulations actually been brought in, and that's in relation to residential leases. So residential leases, landlords are now restricted in relation to how they can deal with their tenants for at least a period of 6 months from the passing of the regulation. And that's just not universal. It's only tenants that are affected by COVID. So there has to be a reduction in income in the household. There has to be a material change made as a result of COVID. And that material change has to have resulted in a 25%, at least a 25% decrease to the income of the household. So if you are unaffected, if you have had a decrease but it's not 25%, then this legislation will not assist you. What it does is basically prohibits the landlord from taking action against you if you fall within this affected category, and it prohibits the tribunal or equally being able to evict you or take action against you. But what it doesn't do, and this is important, it excludes certain activity. So if you're a tenant and you've damaged the property and you need to be evicted for that reason, this doesn't apply. If you are a tenant, there are 4 particular sections where it's not going to apply to you. So there is a fairness in all of this. No, you can't just get away with anything and not be evicted. If you're running illegal activity at the premises and the landlord finds out, well, I'm sorry, you can still be evicted. But if you are COVID affected, then it's worth getting some advice, because there will be restrictions on what the landlord is able to do in a residential tenancy sense. Now, in the retail tenant space, we haven't seen those regulations yet. And in the Act, it does say, in particular circumstances, that essentially will be prescribed. We haven't seen those yet. So maybe they'll be equivalent to or reflective of what happened in the residential space, but we haven't seen it as far as retail or commercial is concerned. So what we're left with there, and we've heard this from the government a lot, you guys need to negotiate with your landlords. You need to come to an arrangement, acting in good faith, both landlord and tenant, to see everybody through the outcomes of this COVID lockdown and the restrictions that are placed on everybody. So those discussions are happening now between landlords and tenants. There will be something coming into place legislatively by way of regulation, but at the moment that hasn't happened.
Okay, so what is the difference between an abatement and a deferral, and I guess what are the pitfalls between the two of them?
It's a really important question, because if you're discussing with your landlord from a tenant's point of view, and the landlord says, okay, it's okay, no problems, just pay half rent this month. And you go, oh, great, fantastic, only half rent. But what does that mean? Because under the terms of the lease, remember, it's still a contract and it's still in place. Under the terms of the lease, you're supposed to pay the full amount. Now, if the landlord is abating that, then paying half means you never pay the other half. and they've made an exception because they've said, no, you never pay that. If they don't say anything, however, are they just deferring that? In other words, yeah, you don't have to pay half rent now because cash is a bit tight, but in brackets, but you'll have to catch up later. Now, it's really, really important that you make that clear. So if you are in negotiations with your landlord, don't stop when they say, look, 20% off this month, no, only pay half this month. Go back and say, is this an abatement? In other words, it's not deferred. We're not going to pay it later on. This is something we're sharing. We're sharing the loss that we're both suffering as a result of COVID, and I'm not going to be paying that to you at all. So commercial tenancy, retail tenancy, if you come to that deal and it isn't clear, make sure you get that email back to the landlord and confirm this is an abatement. It is not a deferral, and I will not be having to make up this half some stage later down the track.
Well, I also understand that a lot of leases have personal guarantees. Will the directors be liable by the end of this whole COVID crisis? I mean, are they able to get out of it?
Well, no, again, what we've got is a contractual arrangement between the parties. And as you quite rightly say, if directors have personally guaranteed performance and there's a breach in relation to performance, then that director is still on the hook. An abatement will apply to director liability as much as it will to the principal company. So that's good. But again, if it's unsaid and the end of the lease comes and the landlord says, well, remember those 3 months that I gave you half rent, you've now got to pay it, and the company can't, then the director's guarantee will still be there. And the director will, if the company can't pay it, be personally required to catch up that rent at a later stage. So again, my advice to everybody is if there is a personal guarantee, be open about it. The abatement applies to us and to the company and to any personal guarantee. I as a director, am also released because this rent is abated. So again, be clear about it, but contractually, the director, the personal guarantor, will still be bound in the same way that the company is.
Have you seen any innovative type of arrangements between tenants and landlords?
Look, there's lots and lots of options being floated around at the moment, and that's a good thing, and people are doing that in good faith. Everything from, we know you can't pay, so just don't. We're strong enough, we can get through this, and we know you have zero income because, I don't know, you're in hospitality, you're a restaurant, there is zero income coming in. And the landlords may be realistic enough to know it's just not possible to get rent. So some are saying there is an abatement, we will abate the rent for a certain period of time. Others, however, particularly the larger ones, are saying, well, that's great, but let's share this. And they'd be saying, for example, okay, we will abate the rent for 3 months for 50%, but let's add on at full rent to the end of the lease when all this is over, 3 or 4 or 5 months extra. So we'll get some money that we weren't anticipating because we're extending the lease, but during this cash crisis, we will share the burden with you. So that's something that we've seen come across our desks a little bit. But what we're also seeing, similar to the residential situation, is not all landlords are just accepting your opinion or your assertion that, yes, this is affecting us. Many are saying, well, that's great, but show me your books. And if you have got a 20% reduction in income, then sure, I'm happy to talk to you about some rent abatement. If you have got a 50%, we're happy to talk to you. But hang on, you actually haven't lost anything. You're actually still being productive. And in which instance, the landlord would quite rightly say, well, no, why? Well, why do you need a rent abatement or a rent deferral when you're actually doing okay?
Yeah, well, fair enough, right?
Yeah,
So, so thanks for your time. I think that's given us quite a bit of clarification there, Tal. We look forward to seeing the commercial tenancy regs come out and give us a bit further light on that.
Yeah,
thanks for your time.
Yeah, thanks, Adriana. Bye.